Your narration mother is back. And if you see a fly because I'm in the garage, just go ahead and name her because she might come back. Let's read the response to the opposition of the motion that I read earlier this week. Now, this is from Ellen Garofalo, who is one of Blake Lively's attorneys. And I think that Ellen Garofalo is the woman who was Taylor Swift's attorney at one point in time. So let me read to you the response in opposition to the motion. Okay. Dear Judge Lyman, as counsel for Wayfair Studios, LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie, LLC, Melissa Nathan, the Agency Group PR, LLC, and Jennifer Abel, collectively the Wayfair parties, we write in opposition to Miss Lively's motion to modify the court's case management plan and scheduling orders. Miss Lively has not shown good cause for her proposed modification. First, Miss Lively has known about the recent produced and forthcoming documents for a month, long before she agreed to take defendant's deposition beginning on September 15th. On August 4th, 2025, Miss Lively moved to compel a further document production from the Wayfair parties and sought several months' worth of additional communication. On October 11th, 2025, the Wayfair parties opposed Lively's motion to compel, but indicated they would produce numerous additional documents. Following the briefing, the parties agreed to September 15th, 2025 for Steve Sarowitz's deposition, September 18th and 19th for Jamie Heath's deposition, and September 21st and 22nd for Justin Baldoni's deposition. In other words, at the time the parties agreed on the deposition dates, Miss Lively knew that the additional documents would be forthcoming prior to the depositions. Second, Miss Lively will have Mr. Sarowitz's response, non-privileged signal messages, by September 12th, which is today. Miss Lively incorrectly claims the Wayfair parties insisted they would not produce signal communications prior to the date of Mr. Sarowitz's deposition on September 15th. The Wayfair parties specifically told Miss Lively that Mr. Sarowitz and Miss Melissa Nathan's responsive, non-privileged signal messages would be produced by September 12th. Finally, Miss Lively misleadingly implies the Wayfair parties seek a blanket 30-day extension of the discovery cutoff date. In fact, the Wayfair parties requested an agreement solely to take the deposition of Taylor Swift during the week of October 20th to 25th due to Ms. Swift's pre-existing professional obligations. Whether the court agrees to a broader modification sought by the plaintiff, the Wayfair parties respectfully request that the court modify the scheduling order for the sole purpose of accommodating the third-party witness, Taylor Swift, who has agreed to appear for deposition, but is unable to do so before October 20th, 2025. And you better believe that Michael Gottlieb has already come on the docket and been like, let me file a response to their response. So I'm going to read that to you as well. Here is the latest order this is not the order, sorry. Here is the latest item on the docket. This is from Michael Gottlieb, who is Blake Lively's exhausting attorney. And here we have another long-ass winded word salad buffet from Texas Roadhouse. Dear Judge Lyman, Plaintiff Blake Lively respectfully submits this reply in further support of her letter motion to modify the discovery schedule dated September 11th. In opposition to Ms. Lively's motion, the Wayfarer defendants assert that they are entitled to an extension of the discovery schedule for the sole purpose of taking the deposition of third-party Taylor Swift. The Wayfarer defendants have repeatedly sought to bring Ms. Swift into this litigation to fuel their relentless media strategy. In this latest effort, the Wayfarer defendants assert, though notably without evidence, oh, you mean what your client doesn't have either, Gottlieb? You mean evidence, which you've never seen any of. Okay. that Miss Swift has supposedly agreed to sit for his deposition sometime between October 20th and 25th, some 3 weeks after the close of fact discovery in this matter. Yet even if one were to take the Wayfair defendant's representation at face value, they have not come close to establishing good cause for their requested relief. And then they cite a case law that includes Fallout Boy. The Wayfair defendants assert that Ms. Swift is not available for the deposition until October 20th, 2025, yet are silent about their efforts, if any, to schedule this deposition during the existing discovery period. That is likely because, as explained in the attached correspondence between the parties, Ms. Swift's Wayfair defendants do not appear to have contacted Ms. Swift's counsel regarding a date or location about the deposition until earlier this week. In this respect, the Wayfair defendants' lack of diligence and disrespect for Ms. Swift's privacy and schedule is astounding. Michael, shut the fuck up. Discovery has been ongoing for more than 6 months. And what has Blake Lively produced? What has your client actually produced? Oh, that's right. Nothing. And Ms. Swift is someone whose calendar should be presumed to be packed with professional obligations for months in advance. Why would we assume that if there wasn't an album announcement? Why would we assume that, Michael? Are you in reality? At any point over the past 6 months, the Wayfair defendants could have noticed a deposition, served a subpoena, and negotiated an agreeable time and place for this deposition. But they did not. Instead, the Wayfair defendants previously noticed Ms. Swift's deposition in May 2025, accompanied by a barrage of press stories covering the same, only to withdraw the subpoena to much fanfare. Now, without explanation, long after dates and locations for all other party and third-party witnesses have been negotiated and agreed to, and without ever serving a renewed notice of a subpoena, the Wayfair defendants come to this court and demand the right to take this deposition, and this deposition alone, more than 3 weeks after the close of fact of discovery and 10 days after the parties are due to exchange expert reports. Michael's mad that Taylor agreed to sit for the deposition with the Wayfair parties and not him. That's what this reads as. Michael's really butthurt. Blake is really butthurt, allegedly. The Wayfair defendants do not even attempt to explain their need for this deposition, which you don't have to. They don't have to. Such a showing would be expected for any deposition occurring after the close of discovery, especially for a third party, but it is even more relevant for this third party, whom the Wayfair defendants have consistently sought to use to generate a media spectacle in this matter. Lest we forget, Blake Lively's the first one to ever mention Taylor Swift in her filing. Did we forget that? The paper trail shows. The paper trail shows, Michael, that, you're an idiot. Okay, where are we? Nor did the Wayfair parties address the potential disruption to the case schedule, including the potential need to take additional discovery and depositions following this deposition, as is common for third-party depositions. Indeed, the need for the potential follow-up discovery, requests, and depositions is why third-party depositions need to be pursued with diligence in the discovery schedule, and the Wayfair defendants should not be rewarded for their inexplicable failure to do so. In sum, the Wayfair defendants have shown no cause, let alone good cause, for their requested extension. Their request should be denied. Signed, respectfully, Michael Gottlieb. I can't wait for this man to get disbarred. Okay, now let's read the part of the email that he is talking about, that he addresses under the heading that says Taylor Swift. It says, "We also discussed the Wayfair party's proposed deposition date for Taylor Swift, which you raised for the first time yesterday. For weeks, you had Ms. Swift's deposition tentatively noted on the deposition chart for September 22nd, but never sent a notice of any subpoena confirming that date. Do not appear to have ever conferred with Ms. Swift's counsel regarding the date and location, nor did you discuss with us how this could possibly occur, given that September 22nd was also slated for the day of Mr. Baldoni's deposition, which was scheduled to take place. And then it's a little bit redacted. Then yesterday, Kevin Fritz stated that Ms. Swift is only available for a deposition from October 20th to October 25 and redacted. On the call, we asked what relevance there is for Ms. Swift's deposition at this point, who is a witness the Wayfair parties previously noticed and then withdrew with much fanfare, only now to ask the entire deposition calendar be extended for 30 days to accommodate. One would expect an explanation on the ways in which the witness was key and essential to the defense. Instead, when we asked what the relevance was of the witness, such that you needed an exemption from the deposition deadline and extension of the calendar, you simply stated that, and it's redacted. There are over 100 witnesses listed, redacted, most of which are not being deposed in this case. That alone cannot possibly be your justification for eviscerating the current case calendar. We do not consent to any depositions, let alone depositions of third parties with only tangential relevance to the claims.
Yeah, oh shit, it's a busy day on the docket. Taylor Swift's attorney, Venable LLP, has stepped into the conversation, and this is what they just posted. This just got on the docket, literally at 11:19 PST. Dear Judge Lyman, Venable LLP represents non-party Taylor Swift. I am writing in response to the letter from counsel for Wayfair delivered to the court yesterday. Ask counsel for the parties known. Since the inception of this matter, we have consistently maintained that my client has no material role in the action. Further, my client did not agree to a deposition, but she is forced into a deposition. We advised, after first hearing about the deposition just 3 days ago, that her schedule would accommodate the time required during the week of October 20th if the parties were able to work out their disputes. We take no role in those disputes. But, so you didn't agree to the deposition, but then you agreed to the deposition? Come on. We're not stupid. Douglas Baldridge, Catherine Wright Moroni. You agreed to the deposition, period. You agreed to it. You're not forced into a deposition. You agree to the deposition. Let's be for real. Don't try to spin this like Taylor Swift wasn't involved. Like, we know she has valuable information, and so does the Wayfair side. That's why they deposed her. You don't have to agree to a deposition. Let me tell you why this letter is a little bit misleading. The implied lack of choice. The letter makes it sound like she's been dragged into this against her will. In reality, agreeing to the dates after a subpoena or the threat of a subpoena is a form of agreement. You don't show up unless you accept the compulsion. Party versus non-party nuance. Taylor isn't named as a party, but because Blake invoked her repeatedly in promotion and litigation filings, the judge may find that she has unique, relevant knowledge. That justifies her deposition. In agreement versus scheduling, her lawyers are splitting hairs. We didn't agree, but here are the dates, we're free. To the court and to lay people, that looks like a functional agreement to a deposition, not just a voluntary one. Can she deny the deposition? Yes, by moving to quash, or she can object. But if the judge overrules, she still has to sit for the deposition. Was she forced? Only in the legal sense of compelled by subpoena or court order, not dragged off the street, but also not purely voluntarily. Why the language matters. Her lawyers want to protect her image. She's not choosing to wade into the Blake and Baldoni lawsuit. She's complying with a legal process that she views as relevant to her. In plain terms, Taylor Swift's lawyers are technically correct that she didn't want this, but saying she's being forced makes it sound harsher than it actually is. Once the court allows it, she is legally obligated, and by offering October dates, she's effectively agreeing under protest. So her lawyers are just trying to, make her look good, which they're just splitting hairs. Taylor's lawyers saw all of the press that is getting Taylor Swift right now, and she's trying to release something today, so they're trying to spin the narrative and get the eyes back on what she's actually releasing today instead of this lawsuit. So they're trying to say that she was forced into the deposition, but she wasn't forced. If she was forced, her lawyers would have motioned to quash, or they could have objected to her being deposed. They're upset. Her PR team is super pissed because she's trying to release something today. This is what her website currently looks like. She literally has a countdown on the website that's about to be, it's about to be fulfilled probably by either noon or midnight tonight. So her team is scrambling to do everything they can right now because they don't want the attention
off of the website, off of her announcement. So they're like, she was forced. Nobody forced her, girl. Don't sit here and lie. Lawyers love to split hairs and spin the narrative so that their client is protected. That's all this is. That's all this is. Exactly right. And I decided to see if I could come up with some questions that could be potential questions in her deposition that are asked. And here's what I came up with. Other than granting a license for your song, My Tears Ricochet, did you have any creative or contractual role in It Ends With Us? Shows Taylor was minimally involved and undercuts any narrative that Blake brought her in as a partner. Did Blake Lively ever tell you that she needed you to publicly support her in connection with this movie? Forces Taylor to either deny hurting Blake's claims or confirm supporting the threat narrative. Did Blake Lively ever suggest, directly or through others, that she would release your private text messages if you did not issue a public statement of support for her? This is probably the most explosive, because if Taylor confirms even the suggestion, it's devastating for Blake's case. After this alleged conversation, did your relationship with Miss Lively change? If Taylor admits that she distanced herself, that implies credibility to the coercion story. Did Blake Lively ever complain to you that she was not given enough control over the final cuts of the film? This positions Blake's lawsuit as a power grab and not harassment. Did Blake Lively ever connect her request for your support to her disputes with Justin Baldoni or Wayfair? And this suggests that Blake weaponized Taylor's influence as leverage. Were you consulted about casting decisions as Mr. Baldoni publicly suggested? If so, who brought you into those discussions? If Taylor says Blake showed me the tape, it highlights Blake using Taylor's name inappropriately. If she says Justin showed me the tape while I was with Blake because he was showing it to Blake, what do we got there? Were you comfortable with your song being positioned as the centerpiece of a marketing campaign, or did Blake Lively push for the placement? This shifts the narrative from Taylor gifted her song to Blake exploited the connection. After these incidents, did you continue to socialize with Miss Lively in the same way as before? If Taylor says no, or less, it demonstrates that there was real strain, supporting Wayfair's claims that Blake drove people away. Did you ever tell your father, Scott Swift, about threats or coercion from Blake Lively? Reinforces the Scott Swift thread, which is he allegedly told Baldoni's side about the text messages. Here are some other questions that they could ask that might reveal some different types of answers. Did Blake Lively ever ask your permission before invoking your name in interviews to promote It Ends With Us? Were you aware that Miss Lively repeatedly referenced you in the press when discussing the film? Did you authorize Miss Lively to present you as a creative decision maker of the film? Did you personally select or approve casting decisions for the film? Did Blake Lively ever tell you she told others you were involved in approving casting? Would you describe your relationship with Miss Lively today as close the way it once was? Have you distanced yourself from Miss Lively socially or professionally since these events? To your knowledge, has Miss Lively made similar threats or ultimatums to others in connection with this project or others? Did Miss Lively ever suggest that you use your influence with your fans or the press to help her win disputes about the film? Did Miss Lively ever express frustration to you about not having the final cut of the film? Did Miss Lively ever express frustration to you about incidences that made her uncomfortable on set? Did she ever complain that she wanted control over the marketing or editing process? Did Miss Lively ever connect her legal action to her dispute about creative control? Did Miss Lively ever threaten to release or disclose your private communications to pressure you? Did you ever feel you had to be cautious about what you shared with Miss Lively because of the risk she might use it against you? Do you consider Miss Lively as a trustworthy person today? Would you say Miss Lively has ever misrepresented your involvement in her projects? Do you feel Miss Lively has used your name to advance her own career interests without your approval? These are just some of the questions. Let me know what other questions you think the Wayfair side should ask Taylor Swift, because somebody's going to get in trouble. and it's gonna be Blake Lively.